Hello, everybody. Welcome to Justice is a Process. This is Steve here, and I'm coming to you today with analysis of the Lori Ann Phillips trial, days 3 and 4. And man, let me tell you, this case is chock full of excitement. Day 3 was basically more of the state's case, where they put forth evidence. They put some experts on the stand. And then day 4, some excitement came. We're going to get into it. Some significant things to talk about in day 4. One of them being the defense putting forth their motion, which is a fairly standard motion to ask for a judgment of acquittal at the end of the state's case. However, in this case, the judge actually starts to question and really lays out the reason why the defense doesn't need to put a case on, but the defense is going forward with a case. Not only are they putting on a case, but they've put the defendant on the stand, and her direct examination is completed at the end of day 4. We're going to talk about all of it, but we're going to talk about why I think the defense has made a tremendous mistake. And this is the part about justice being a process. And this is also something that you see commonly, where defense attorneys overplay their hand, misunderstanding a fundamental fact, which we're going to watch a clip where the judge actually admonishes the state, but he's really talking to the defense attorney in this case, saying, hey, the burden's on the state. This case isn't clear at all. The elements haven't been met. And the state attorney is actually saying, well, we're waiting for the defense to put their case on, because through the defense's case, we're going to make our case. And yet the defense still plowed forward and didn't just rest and say, let's go to closing arguments. Let's make our closing argument and move forward with this thing. Because it's very clear to me, it was clear to the judge, and the state really was having a hard time justifying their charges in meeting the 3 elements that we had to come up with, as we talked about in the opening statements. Those 3 elements are that Lori Phillips caused his death, that she knew she caused his death, and that her actions and behavior were unreasonable, and that she knew they were unreasonable. And those are, well, until the defense starts putting on their case, it was it was it was going to be a tough road for the prosecution to get over those humps, and they were going to be asking a lot of 12 people, to find 12 people to agree that they had met their burden. But anyways, let's get into it, guys. Let's start talking about this case, and let's get into day 3 first off. We're going to start out with day 3. So in day 3, we started out with a crime scene analyst. This gentleman here was he looked at the car, he collected fibers from the car, and essentially the main thing that he found that there were fibers, or there was a fiber that was consistent with the victim's genes underneath the undercarriage of the vehicle. Now, interestingly enough, he also found mysterious electrical tape indicating someone put it there. Was it the defendant? Did he go under there and do something with the car? Interestingly enough, it also came out that the vehicle was driven around, and it was 2 weeks later when he was doing his examination. So the vehicle had been driven around, it had been operated. It was not examined the day after, the day of. There was time that had passed. I found that to be very interesting. But he testified, and then we went on and had, give me a second here, we'll queue up the next witness. Next witness comes on, and this is she's basically an individual that did the DNA analysis. So she finds that the fibers were consistent; they were not a match. She testifies essentially that they don't have the ability to say that What they found underneath that truck was a match. Again, a whole lot of nothing, really. And it's not proving anything. It's not proving anything towards the elements because, again, we can't say beyond a reasonable doubt, which is the standard, beyond a reasonable doubt. They're saying it's consistent. It's potentially likely. The state's going to need other circumstances in order which to link it, which they're responsible for putting on. So they move on next to the lead investigator who gets on the stand. And this is when it kind of gets exciting because the interesting thing, and this is why I'm making the case that we did not need her to be on the witness stand because they played her interrogation. And in her interrogation, she tells her story. And she tells a story that really hasn't been refuted, or and doesn't do much damage to her. It doesn't say that her story's consistent. She didn't know that she hit anybody. He's coming across the front of the car. She's pulling out. She feels threatened. She absolutely says, "Hey, if I would have hit him, I would have come back." Why the defense needs to put her on the witness stand to say the same things again, subject her to cross-examination, subject her to the possibility that she says something that trips up her defense. Why bring clarity? Why answer questions? Why potentially add to the potential of whether or not she knew or not, whether or not she had motive or not? Because it's becoming clear, and it's become clear in the defense's case, that the state's theory here is that yes, while she was abused and she was a victim of domestic violence, that angered her to the point that in the driveway she went from victim to aggressor, and that in that moment, all the anger, all the upset about how she'd been treated, the word she'd been called, that she guns the car into him in an angry moment and ends up knocking him down, not realizing that she killed him or anything like that, but drives off all hopped up, all angry, and leaves and causes his death. And there is the reckless homicide. Now, that's not present if she's not testifying. That's not present if you're not talking about all of the things that putting the friends on and talking about her state of mind. The state had to prove her state of mind. They were choosing not to do that. They weren't calling her friends. They weren't calling the people from the bar. They weren't calling her to the stand. They couldn't call her to the stand. Instead, all of this is coming in now, and it's beginning to paint the picture for the state for them to be able to make their case when before they would have never made the case. But anyways, investigator comes on and he spends the rest of the day on the stand. We hear from her. We hear her statement. And again, to me, at the end of day 3, I'm walking out of day 3 going, okay, it's all much. Why did they charge this lady? How are we getting to guilty of second-degree reckless homicide? So then day 4 begins. Now, I want to show you an interesting exchange. Give me a moment to pull it up. That I think is absolutely horrendous from the judge. Give me one moment here. Let me pull this up. All right, guys. So I want to play this here, and then we're going to talk about it here. This to me is a prime example of just. We're going to talk about it once you hear it. But I could not believe what I heard this judge say, and I'm assuming this probably happens in courtrooms every single day. But this is an absolute injustice here. This is a judge getting in the way of justice, getting in the way of the process of justice. And a lady is facing 25 years, and this is this guy's attitude. Let's hear it.
Yeah, if you want to, go ahead.
So Clyde helped us fix, off the record,
Yeah,
Clyde helped us fix the sound issue.
yeah, okay, good. So this can also be off the record. Is there any chance we're going to be done this morning or today with your witnesses?
With our case in chief, no.
Okay. All right. I mean, I was told it was going to be done halfway through today. Is there a way it can be done today?
We've already cut some witnesses out, Your Honor,
All right.
from our list.
Just see if there's ways to speed this up because it's
Yes.
taking longer than I've been informed. waiting for Mr. Burdick, or can we? There we go. Here he comes.
All right, guys. So let's talk about this guy. Let's talk about this Yahoo, this judge here, Elliot Levine. I mean, come on. This is crazy. If you just heard what he just said to the prosecutor, he's asked them to cut witnesses out. He's got some sort of time frame that he wants this trial done in, and he is asking the state to essentially conclude their case early, to not bring information to the jury that the state feels is pertinent to their case. Listen, if this case needs to go on for 3 weeks, so be it, if it means getting a proper case out. What this judge has just done here is he has just disrespected the victims in this case by saying this man who lost his life, that this, who the state is representing his interest, is representing his story, is saying, listen, it's not that important. I mean, if it's not that important, why are we there? Why are we having a trial, right? Because the stakes are high, in the sense that if this case isn't presented properly with questions, and again, this goes on into day 4. This seeps into day 4. He continues this behavior and it continues it all the way up into the end of the day of today. And to me, it is abhorrent. It is wrong. And this judge should be brought to task, because apparently he has some sort of hearing on Monday that he's worried about. And I can't even believe it. But to me, this is a big problem right here, because when it comes to a trial where someone's life is on the line, or where a victim's family is depending on the state to be able to put forth their best case and all their evidence and have all the questions asked, to have a judge getting involved and suggesting that, hey, we don't have time to ask questions, we don't have time to get it done right because he's got something bigger happening. What's bigger in any of these people's lives? What's bigger in the victim's life, the victim's family's lives, than seeing the case for their loved one put forth? What's bigger than the defendant in this case, who wants to have the best possible case put forth, and all the questions that need to be asked, and all the witnesses that need to come on, so that the jury gets the picture? This judge should be ashamed. But anyways, this is what they're dealing with and contending with. But anyways, we move into day 4. Let me get day 4 up here, and get off my soapbox there. But that really angered me tremendously when I saw that. All right, so we move into day 4, and essentially day 4, they put the lead investigator on the stand. He goes over videos showing the interactions at the bar, that all that evidence gets put in. And that's really it. The state doesn't put on a theory of how they believe the crime is going to, how the crime occurred. But we get the lead investigator on the stand. Hold on here. Let me find the next witness. All right. So basically, after the investigator gets on the stand, they have someone come in and testify as to what they found on the car, in justifying essentially why they did not end up calling up the information for the car's computer, and what they, essentially further evidence showing that the car did not appear to have any damage. I mean, it's been a bizarre case. But anyways, they get done with this, the state rests, and then this exchange occurs. And I want you to watch this exchange, because this is unbelievable. But this is also, you're going to hear right here, in my opinion, this is a case where the state has failed to meet their burden, and the defense should not be putting on a case right now. And in putting on a case, they are helping the state out. Listen to this exchange and listen to how this goes as the defense files their motion asking for a directed acquitted or verdict of acquittal. It makes a strong case why, and then listen to the exchange between the judge and prosecutor. It's going to go on for a few minutes. Trust me, it's worth listening to. Let's pull it up here.
Witnesses at all?
I have a motion first, Your Honor.
Yeah, I understand you would, but are you, just in case, were you ready with
Just in
defense?
case I am.
Okay. Go ahead.
Your Honor, at this point, I move the court for a directed verdict of acquittal. The state's elements are fairly straightforward. Number 1, causation. showing that Ms. Phillips did cause by a substantial factor Mark Phillips's death through her actions. Number two, recklessness. Recklessness requires proof of individual elements to include that Ms. Phillips herself created a substantial risk, that risk was unreasonable under the circumstances, and that Ms. Phillips was personally aware at the time that she acted that she created both a substantial and unreasonable risk of death or great bodily harm. The state's focused a lot of its case in this matter on showing the mechanics of a possible collision here, but we've heard absolutely no testimony that a reasonable jury could conclude beyond a reasonable doubt that Ms. Phillips was reckless under the circumstances alleged. There's been no testimony indicating that Ms. Phillips was the individual creating the risk alleged. There's been no evidence that could rationally support the presumption that Ms. Phillips would have been unreasonable fleeing from Mr. Phillips under the circumstances. Moreover, where I think the evidence is particularly lacking, I'm unaware of anything that would indicate, particularly to the level that would allow a rational jury to conclude beyond a reasonable doubt, that Ms. Phillips was actively aware of a substantial and unreasonable risk at the time of the actions. Dr. Reichert himself testified that this matter very well could have occurred in the manner that Ms. Phillips described, and his manner of death in this case was undetermined, not homicide.
And remember, that is exactly what I said, what we said when we were watching that doctor's testimony. I said that doctor's testimony essentially is end of the case. Again, this guy's making the case himself. I mean, I don't know why he's getting in his own way. He's making the case here for why he shouldn't put on a case. It's a case over. He has no burden. What are you doing? Why are we going to go spend another 6, 8, 10 hours putting on a case, helping the state out? But anyways, let's proceed. It's unbelievable.
Homicide. I also don't believe that the state's anywhere near the elements for 1060A. We don't have, number one, there's been no established legal duty to that Ms. Phillips would have, particularly to a spouse in this case. It has to exist in Wisconsin law explicitly, not just the general duty of care that everyone owes one another in the community. That doesn't exist in our case law. It doesn't exist in our statutory law, and I think it would contradict all of our domestic violence policy that we have on this issue, suggesting that a domestic abuse victim owes a particularly higher duty of care to her abuser under those circumstances. Number two, the state's presented no evidence that would cause a rational jury to conclude that Ms. Phillips would have been aware that Mr. Phillips had been injured and failed to act under those circumstances. So I do believe that this is one of those rare cases that is appropriate for a directed verdict of acquittal. I would ask the court to rule in that matter at this time.
State's response?
Your Honor, the state does not feel that a directed verdict is appropriate. We believe that this case should continue. We should believe that pending the defense's presentation of their case, that this is a matter that is appropriate and proper for the jury to decide. Your Honor, I'll touch on cause, that Ms. Phillips caused the death of Mark Phillips. She is, by her statements and by observations of Dr. Reichert, there are no other reasonable causes that a jury could conclude. I guess from our perspective, in terms of beyond a reasonable doubt, at this stage, Judge, all inferences are drawn in the favor of the state. The injuries here are significant enough, as talked about at length by Dr. Reichert, that the cause of death for that driveway at that particular time where Mr. Phillips was found was the truck. That truck was incontrovertibly driven by Ms. Phillips, both by, I guess, her statements, the corroborating evidence, all of the video and timeline information that has been presented about what happened after she left. Your Honor, as far as the pure cause there, we know it's not a slip and fall. We know this isn't a heart attack. We know that Mr. Phillips didn't get drunk and fall asleep in the snow. The only thing that reasonably could have been concluded, as far as what Dr. Reichert's testimony for the extent and extremity of the compound fractures and a lot of the things that were heard, would be, I guess, a significant fall. There's also no evidence to suggest anything like that. So as far as the actual physical corroborating evidence for the cause of death, the truck, defense counsel also doesn't note that the gene, from the state's perspective, the hair fiber, or not the fiber, the Consistent fiber that Ruth Hank testified to was found under the vehicle, lodged in the vehicle. It is consistent with the jeans that Mr. Phillips was wearing when they recovered him. We heard testimony about, he was wearing the same clothes, that kind of things. We visibly saw many pictures of the jeans that were ripped. We know that they weren't ripped by, or a jury could at least infer that they weren't ripped by the paramedics, tri-state, that kind of thing. When they removed them, there was other testimony regarding that. So as far as the pure cause, that corroborating evidence with Miss Phillips' version of events, that there was an argument in the driveway, that she left in the truck. She is the only person driving a vehicle in proximity to Mr. Phillips and had the opportunity to hit him. It is of the same character, nature, and everything we would expect as far as cause. We believe that a jury could conclude that the first element, cause, was met under those circumstances beyond a reasonable doubt, and it is certainly not something that no rational fact finder could determine cause. Attorney Zacher had brought up through questioning other types of, if he was dragged or hit with the mirrors or fell under the truck. But again, Your Honor, it's one of those, the actual causal mechanism for the death of Mr. Phillips was the weight of that truck, the driveway, him being in between those two forces in a vehicle driven by Miss Phillips. As far as
I asked the state, what is the theory?
And this is it right here, guys.
What is the theory of the accident by the state then? Is it?
I want you to think about this for a minute, right? The judge is telling the state that it's unclear to him how this happens. It's the burden of the state. You've just rested your case. You've got to have shown clearly how this crime occurred. And this prosecutor right here is saying, well, we proved that the death had no question. All right, it happened. The question is, was she aware? Okay. And was her actions reasonable in what she was doing when she was operating the truck? And what they haven't addressed is, okay, while it is possible that she could have run him over, but they haven't put any proof towards that that's what happened. There's no proof as to how he would have been struck in a way that would meet the standard of second-degree reckless homicide. What was the unreasonable behavior? What was the reckless behavior? What was she doing? The story that's before the court right now, the only story that's before the court, is that he's charging at her. It's a snowy, slippery night. She's getting out of there, and he's chasing after the truck, and she has to be aware that what's happening at that moment could cause his death. If she isn't aware, if what she's doing is reasonable, if she's not intending to kill him, if she's not being an aggressor, if she's trying to flee for her life, and he happens to fall, gets under the bumper, and gets smashed between the snowbank and the truck. As you can see, it's right there on the turn. There is no case here. And the doctor said there's no way to know. The doctor said it's just as likely that what she said happened is what happened as it is for the state saying that it happened in a way where there's criminal culpability. And now, keep in mind that at this stage where we're at right now, the state gets the benefit. In other words, the state is going to get every benefit and every break in order to keep this case going and move on to let the case go to the jury. But when the case gets to the jury, the state no longer gets that benefit because the state has the burden and had the burden to prove these things. So watch this exchange. This is an unbelievable exchange between the judge and the prosecutor, as the prosecutor continues to not get what the judge is saying and struggle to answer the questions. This is disturbing, but it also should have been game over for the defense. Let's rest the case. Let's put this thing before the jury, and let's make the argument you just made to the judge, and let's argue the fact that, guess what? The state has not met their burden. They have not proven what they need to.
That he got run over by a wheel, that doesn't seem to be supported by the facts. What is the theory of how the accident went down?
Your Honor, we believe that the crushing mechanism and that it was the actual tire, the weight of the truck going through the truck into the wheel into Mr. Phillips' left side of his body is the cause.
So there's no tire tracks, nothing on the body, but nobody's testified to that, right?
There was no tire tracks in the body. That is correct.
Okay, so the theory is that, I just want to understand what your theory is that he fell and then was run over by the back tire or something?
Your Honor, our theory is that Miss Phillips drove a truck, and I'll get to the recklessness element afterwards, and why we believe that's appropriate to continue. But our theory is that Miss Phillips went over Mr. Phillips in the truck.
Okay, you're not understanding my question. What I'm asking is, what are the mechanics? Did he go under the truck? Did he stay off to the side of the truck? And I'm sorry I'm not trying to be insensitive to the victims here. It's tragic he's died. What I'm trying to understand, what the theory is, the mechanics that the state is alleging here. Because you do have inferences in favor of the state. There's a piece of fabric which is consistent with his jeans that is on a drive shaft in the middle of the truck.
This is incredible. The judge is actually having to make the case for the state. He's having to take their evidence and say, look, this is the theory of the case. In other words, he's saying what you're saying right now, I may have to grant this motion. But yeah, look, this is the evidence you have. If you say this is what your theory is, and this is how this evidence applies, although there's definitely alternative arguments, and it may not rise to proof beyond a reasonable doubt, but at least it'll get the case to the jury. I mean, this is incredible. Let's listen more.
Truck. And what the state is trying to infer is that's indicating the body was underneath the truck somehow. But so what's the inference? That he got run over directly, got run over from the side? What's the mechanics of the accident?
So, Your Honor, I understand the court's clarification question. My understanding and argument of the law is that it's a substantial factor. And then also when we talk about the instruction and the law regarding what multiple substantial factors being used to determine cause.
Still not answering my question. I understand you believe the truck was a substantial factor. I understand that. What you have no theory as to exactly the mechanism of the accident, of how the vehicle crushed the body.
Your Honor, Mr. Phillips, our theory is that Mr. Phillips is coming around the front of the truck from the right to the left, and then Miss Phillips hits the gas or takes off, or however she describes it, and she at that time went over Mr. Phillips with the truck.
So he was never at the window. She's lying about that. Is that what you're saying?
Your Honor, I will concede that in terms of whether it was the front or back tire, I cannot answer that.
Okay. Now the next thing is the element of unreasonableness. What do you want to respond to that? Assuming the facts get you to cause, get to unreasonableness.
Your Honor, as far as the reasonableness of the situation, we believe that, evidence has been presented regarding Miss Phillips and her flight and her state of mind and things like that. We've heard that the biggest piece of evidence in terms of what we would expect, I don't know. It was mostly discussed during openings by Attorney Zacher. We haven't actually gotten to that, a lot of that evidence in the state's estimation. As far as the unreasonableness, it comes down to credibility and what the jury understands as far as Miss Phillips, the way she's presented these version events and what they believe. That is appropriately in the purview of the jury, that credibility for the actual reasonableness of her flight.
Just so it's clear, defense has no burden of proof at all. The state has the burden of proof. You have to prove unreasonableness.
Correct.
Beyond a reasonable doubt.
Correct.
So what is the unreasonableness of the actions? Is it just because there's a dead body, it's unreasonable?
No, you're.
I mean, I hope you all caught that right there. That is unbelievable. He's reminding them that they have the burden. Essentially, what this guy is saying is listen, we are waiting for the defendant to testify. And then we are going to cross-examine her, and we're going to make our case while she testifies. And the judge is basically saying what you presented so far doesn't meet the standard. It's barely meeting the standard if it's meeting it at all. And I'm struggling to see where you're saying she was unreasonable, because everything that's on the record right now says that it was reasonable. That's what her statement is to the police. There wasn't a hard line interrogation where any of that was questioned. And at the the point right now, all inferences, all discussions have been around the fact that this guy's the victim, that is attacking her, is angry at her, is acting unreasonable, and she gets home and says, "I'm leaving," and he comes out, starts attacking, and she says, "All right, I'm heading out, and I'm leaving, and I'm going to leave the situation." Which again, how do we get to unreasonable here? And the state's saying, "Well, we're gonna get to cross-examine. We're gonna wait." The defense talked about this in their opening of the evidence they're going to present. We're waiting for them to put it on so we can then use that to make our case. This should be key to the defense attorney to say, pump the brakes. We don't need to put a defense on. Again, remember, the burden, just like the judge said, is on the state, not the defense. They don't have to prove a thing. And this is one of those instances where if she gets convicted, it will not be because of what the state put on in their case in chief. It will be because her attorney put a case on that ended up clearing up a lot of the questions, a lot of the things, and that jury takes it and says, instead of looking at the state's case, they're looking at her. Do they like her? Do they like her story? And do they believe her? No need in this case whatsoever to put the defendant on the stand. She testified to them already in her statements. There was nothing that the state brought in that made her statements look as if they weren't truthful. Big mistake coming up here. But let's finish this off and listen to the rest of what the judge has to say.
Your Honor. The unreasonableness, we believe that there is evidence, plenty of evidence in the record that a reasonable fact finder could conclude that Ms. Phillips was angry, that Ms. Phillips was having an argument, that argument was not exactly how it was described, and that she, in her words, took the F off, or however she described it, that particular point of the video, that he was in front of her, that she saw him, that she was aware of his general location, and she, not to flee necessarily for safety, but just to go because she is upset, arguing that kind of thing. The argumentativeness, that is unreasonable. That is acting in the heat of the moment due to anger.
And that addresses the awareness aspect. So I believe that addresses the awareness aspect too. And the reason that's important is because each of the elements have to show some evidence that's not some evidence in most favorable to the state, that a reasonable jury could come to the conclusion at this point, when a motion is brought at this point, beyond a reasonable doubt, that those elements were met. If I accept all those facts as determined by the state as relevant evidence, the court is finding that there's a reasonable jury could find beyond a reasonable doubt, beyond a reasonable doubt, if looking at the facts as stated by the state. Of course, it's a different standard once the case is done. Given that, the court's denying the motion.
Thank you, Your Honor.
All right.
All right, so the judge denies the motion, and then we move on to the defense's case in chief. And basically what the defense chooses to do is they put on a fairly innocuous witness who testifies as to, I guess, a domestic violence incident that occurred, which ultimately a lot of what they're trying to accomplish gets blocked because it's not really relevant. But again, the issue I have with what the defense does here and what I'm about to describe to you is the fact that what they're doing inadvertently is they're creating the basis for why the state can argue that she acted not as a domestic violence victim, but she acted out of anger towards him because of how he was treating her earlier in the evening, and that she plunges forward with the car, not because she's trying to flee, but because she's just had enough of his BS. And she goes forward and makes contact, and there you have second-degree reckless homicide. And again, without her testifying, without putting the friends on, without building up to all this, without continuously hyper-focusing on this, there is no case to be made without all that happening. But anyways, they put on the friends that were with them. They discussed the situation. They discuss what happened, which has already been discussed in the police statements. They go into greater detail with text messages. They put text messages in showing that they're texting back and forth, that this lady is Lori Phillips is angry, is upset with how she's being treated. But also, of course, there's concern in the messages with how he's treating her. They talk about how he is essentially a drunk that can't handle his alcohol, and that eventually they leave the bar, go home, and of course nobody knows what happens after that. But what they can prove right now is that you have two people in a highly volatile situation where it's going out of control. This guy's put hands on his wife for the first time ever in their relationship, according to her, and things are spiraling really, really deeply out of control at this point. And then the defendant gets put on the stand. Give me a moment here. All right, guys. So I've got it queued up. The final clip we're going to watch is of her describing. Now, this is her describing the moment when the final moment that she's with Mark Phillips. So let's take a listen here and see what you think about this here. This is her describing. She's moments before he's at the car, he's getting things out, and this is how she describes how she left. And this is going to be key right here. Of course, tomorrow they will open with the cross-examination, which is going to absolutely define where this goes. But this is it. This is the moment that they have to. Everything relies right on this moment. Everything that's come in, the state's burden, all that stuff is now shifted to this moment and what this jury believes and how she's received in this moment. So let's watch it, and then I'll give you my thoughts after we watch it, and then we'll wrap this up.
Everything was put onto the passenger side seat.
Was Mark saying anything to you as he was going through all of these items?
Yeah, I mean, he was like, I'm just so you know, I'm changing the locks, which he always said. And then he found, I mean, he was saying a bunch of things that he was just trying to hurt me. But he also found some beer chips to a tavern in Holman. And he said that he was going to go there and go find some women.
Was this in the course of continuing to yell and scream at you?
Yes.
And at some point, did Mark come upon a can koozie?
Now, I want you to understand the issue with that right there, guys, right? She's saying she's a victim, right, of domestic violence. This is why you don't put the defendant on the stand. You don't take the burden on, because what she's just said right there, and we'll see what the state does. Again, this state's shown an ineptitude that's crazy, but if they get her in cross-examination, if I'm a prosecutor, that is the moment right there. That's what's going down on my notepad right at this moment. When he said those words, did you get angry? Did that make you angry? Because remember, she's saying this is moments before she decides to hit the gas and get the heck out of there. Because it is in that moment when she is saying that, when the prosecutor gets her up there. Again, remember, there's been nothing adversarial. There's been no major interrogation where she's been asked hard questions that's come before this jury. It's going to happen tomorrow. But the moment right there is going to be, how did you feel when he said that? He's telling you he's going to go get women. He's going to go take these bar chips and he's going to bring women back to the house. You're going to hear she's going to talk about it. He throws the koozie at her. She's getting angry now. She's no longer being, yes, she's being verbally attacked. But if she's angry in that moment, if she goes from, someone who has, yes, earlier in the night, she was grabbed, she was choked, she was mistreated. But in that moment, all of that anger, she's been drinking, everything comes together and she accelerates. And they can prove that she was angry, in an angry state of mind. And she's only going to prove it in her own words. It never would have been up here if she wasn't on the witness stand. And then they're going to say, hey, there's fibers underneath the car. He's crushed. Look at his injuries. What else are we left to conclude with here? She's angry. She's mad. The only witness is her. Guys, this is why you don't have the defendant testify. If she gets convicted, it's because of what you're hearing right now. Anyways, let's get back to this. It's just so upsetting because they have the case won and they're sitting here doing this. I don't understand it. Anyways, here we go.
That you saw earlier in this trial
Yes, sorry, I forgot about that, yes.
was, did you recognize that can koozie?
Yeah, so Mark bought me that can koozie on my birthday. My birthday was the month prior to that. And it was, well, you saw it, part of it anyway, but it was a can koozie that had like an animated, they were like animated breasts. And it said, "Tits my birthday" on it.
Did Mark do anything when he came across that can koozie?
Yeah, he threw it at me and he said, "Here, this is all you're good for."
What did you do in response to that?
I was like, whatever, and I tossed it out the door. I mean, he was like rummaging through stuff. He didn't.
I mean, I don't know what they're doing here, man. I don't know what this attorney is doing here, right? Like the significance of this and how she flippantly acts as if like, I was like, whatever. You're not like whatever. This man's been attacking you. This man's look, it's coming. It's going to come down like a thunderclap on her tomorrow when they get her on cross-examination. If she escapes it, if Crosse doesn't go that way, but if I'm cross-examining this woman, I am going right at that moment. You're telling me that when he throws that koozie at you and says, this is all you're good for, you're telling me that didn't get your ire up? That didn't get your anger up? That didn't make you angry? He's telling you he's going to go find other women. He's going to bring them back to your house and he's going to go do these things. This doesn't make you angry. This is moments before you're hitting the accelerator and he ends up dead. And you're claiming it was because he's attacking you, and yet he's saying these things to you that's provoking you. And if you hit that accelerator because you were angry, you're guilty, potentially guilty of reckless homicide. And the defense is the one putting this up here, and the state telegraphed it. And this, like I said, if she gets convicted, it will not be because of how the strength of the state's evidence, or at least the strength of their case in chief. It is because she had an attorney who didn't understand what it means when the state has the burden of proof and the defense has no burden. And the standard is beyond a reasonable doubt. Anyways, let's get back to listening to this. It's just so frustrating and upset, but let's get to the significant point where she talks about what happens. Here we
Didn't
go.
even know it went over his head and out the door.
Was Mark calming down at all during this time frame?
No.
And Lori, was anything you were saying or doing causing Mark to calm down or reduce the intensity of his behavior that night?
No, he just kept getting more and more furious.
So as you saw Mark behaving this way at the passenger side of the truck, did you do anything in response?
When he was getting furious? Oh, yes. So I grabbed my phone because he hadn't taken it yet. So I still had my phone. So I wanted to record how he was treating me, how he was talking to me, so that he could hear it the next day to realize the crap that I go through with him when he's drunk.
So were you able to get your phone out?
Partially, yes. I got my phone out, but Mark noticed I had my phone and lunged for it. But I had pulled it back and it like hit the window and dropped straight down in between my door and my seat.
What do you remember seeing about Mark next?
After it dropped, I looked at him immediately and he was furious. It's like I looked at somebody that I didn't recognize at all. And he just took off and came around to come get me in the truck.
When you say he came around to come get you, what was your impression of what Mark was doing there?
He was going to come get me and drag me out of the truck, and I don't know what he would have done. I have no idea what he would have done.
Were you scared that the physical abuse would continue?
Absolutely.
Were you scared that the physical abuse could escalate to something more violent?
Yes.
And when you say that Mark was running around the truck, describe the route that he was going there.
So he went around the door because the passenger door was wide open. He went around the door and ran around the truck.
Was he running very quickly?
Yes.
About how much time would you say elapsed from the time that Mark gave you that look and then tore off around the front of the truck towards your side of the door?
How much time elapsed, did you say?
Yes.
2-3 seconds. I mean, it doesn't take long to get around a truck.
What were you feeling at this point, Lori?
I was terrified. I was scared out of my mind. I was like, my heart was beating out of my chest. And I just wanted to be safe. I wanted to get to safety.
Have you ever been in a position like that, Lori, where you were forced to make a split-second decision under circumstances like that before?
No, not like that, no.
And you said that your heart was pumping. Are you familiar with the term fight or flight?
Yes,
Is that an instinct that you were feeling in that moment?
yes. Well, so when he started running, I wanted to lock my doors because I didn't want him to be able to get to me. So I'm like trying to lock my doors because I was just so afraid of what was going to happen when he got to me.
Do you know if you were able to get the doors locked?
I don't know. I honestly, I don't know. I wasn't familiar with the truck.
Yeah, and you mentioned that you'd only driven this a few times before, maybe?
Right, and the doors lock on their own once you hit like 10, 15 miles an hour, so I've never had to use the door locks.
Now, at some point, did you see Mark clear the front of the truck and reach towards the side of the driver's side?
Yes, well, I know he wasn't in front of the truck because that's the only thing I could see was the front of the truck.
How close would you estimate Mark was to the truck before you made the decision to hit the accelerator?
That he was at my side of the door. He was, I would say he was right at my door.
And Lori, what were you thinking when you, or let me ask you this, did you put the truck into drive and hit the accelerator?
I did,
What were you thinking during that process?
to get the hell out of there.
Were you even spending much time consciously thinking about this?
No, I mean, my husband's here, he's not in, so I should say, when I see forward only, it's because it's dark out and this door is wide open, so my light is on inside the truck. So it's right inside the truck. I can see forward because of the lights, but it was hard to see anything else, but I knew that he had cleared the front because he was not in my vision.
And Lori, is it fair to say, characterize your reaction here as more instinct and less conscious thought process?
100% instinct.
Were you thinking about anything other than getting yourself to safety at that moment?
No.
Was this a position, Lori, that you ever asked to be in?
No. No.
Was it something that you had any time to think about and consider the pros, the cons, and the risks?
No, it was like 2 or 3 seconds.
Once you hit the gas and left the driveway, where did you go?
I took a right out of the driveway, and that's actually when I took my right, that's when that actually, the passenger door shut. And then I drove down a little bit to a subdivision that ended up being, like, when I say a little bit, I guess it was approximately 2 miles away.
Okay, so let's back up a little bit. Is it your testimony that the passenger side door was still open at the time that you hit the gas?
Yes,
So it happened that quickly.
correct.
And why did you pull off in the subdivision, Lori?
I was checking to see if Mark was chasing me.
How did you assume that Mark would chase you to the subdivision?
Well, he would have gotten in his old car, the Outback, Subaru Outback.
Subaru. Now, when you got to the subdivision, did you have any reason to believe that Mark had been injured?
None, no.
Were you concentrating on the physical sensation, Lori, of whether or not the tires were coming up against a snowbank or how they felt on the road as you were fleeing from your husband?
Overruled. Go ahead.
Were you concentrating on the physical sensations of what the truck felt like when you were fleeing from Mark?
I mean, I don't think so, no.
What was first and foremost in your mind when you were trying to escape from Mark?
To get out of there, to get to safety, to get away from my husband.
Did you have the sense when you left that you thought you had hit Mark or struck him in some respect?
Not one time, no.
All right, guys. So there you have it. There's the testimony. The key part of the testimony right there. Now, here's a couple problems that I see right now, and this is the issue. They're trying to. obviously the attorney is trying to focus on the fact that she didn't realize she hit him. This was all in the statement. The big issue that you're going to have is what she sets up here now is she's setting up key evidence. She's giving key evidence that didn't exist. The only person that could give this evidence is her because she's going to subject herself to questioning. And that is, what were you thinking right before this happens? And what she's telling him is she's getting a can koozie thrown at her. She's getting berated. She's getting angry. And he starts coming across, angry because he wants her phone. And she sees him coming across, and he's coming across, and she just guns it forward and hits him in anger and goes straight on through. Now, she may not think that she hurt him or killed him, but it's only a matter, again, because this is not an intentional situation. This is the thing that says, did she act unreasonably? In other words, at that moment, she got angry. She gunned it forward in anger at him because she thought, you SOB, boom, and goes forward. Now, again, what the state's going to do here is they're going to say, we have a moment. We know she's angry. We also now have a defendant where he ends up under the car in a position where a gene fiber can get into the undercarriage. We know he's got 9 broken ribs, compression fractures. We know he's got head injury. We know he ends up in the snowbank. As a result, what does it say? It says that she had to be, unreasonable, meaning she had to do this out of anger, not out of a reasonable reaction. And in this attorney's belief that he has to prove that he doesn't understand the fact that he doesn't need to prove what her state of mind was. They have to prove what the state of mind is, and he's bringing her on the stand and subjecting her to this. I don't understand it. If this case would have gone to the jury without ever having any of the defense information there, this is a not guilty, in my opinion. Now we'll see how cross-examination goes. Is she at risk of getting convicted? I think she's more at risk of getting convicted now. I'm leaning towards acquittal. I don't think the state's met its burden. I'm still questioning why this case was brought in the first place. I think it's pretty clear that she did not intend to hurt him. She wasn't aware she hurt him. And this was a situation where it was an argument and there was zero intent. There was zero unreasonable behavior. I think she did believe she was fleeing. I think there was probably some anger involved. I think it was a mix of both. I don't think it rises to criminal culpability. Hopefully the 12 jurors on it see it that way. But the state's going to make this argument that he was injured, that the driving of the truck is a big deal, that that's a huge factor, and that ends up on top of him, and that she should have known and she should have returned, and that she then goes and leaves the scene. But we'll see how this plays out in cross-examination. But man, I'm telling you, the defense had this case won. If they lose this case, mark my words, it's because they put her on the stand. It's because they presented a case. It's because they forgot that they don't have to prove anything. So anyways, guys, shortly after this clip here, the day ends. So she's still on direct examination. I assume there's probably maybe 20, 30 minutes of a direct examination. Then they're going to be going into cross-examination. Then they're going to be putting on another witness. I think the defense has one witness to put on, and the state didn't say whether they would have a rebuttal case or not. But the judge made it very clear he wants the case is wrapped up by noon, and he wants closing arguments. He said, in his opinion, he wants to have the testimony wrapped up, I guess, probably by like 9:30, 10 o'clock. Closing arguments going off at like 10:45, and the case going to the jury by lunchtime so they can begin their deliberations. And what I'm sure he will encourage and hope is a very short deliberation. But I don't know that it will be, because I think there's going to be a lot to talk about here. I think it's going to be a tough one, and it's not, unfortunately, I don't think it would have been that tough if the defense doesn't put their case on. But anyways, guys, that's where we ended up. Where I feel we're at right now, I think we're still leaning towards an acquittal here, but I think we're getting dangerously close to where she could be getting into some trouble. Put in the comments what you think. Where do you fall? What do you think? I've been going through the comments. I know there's some people that did not like her testimony, didn't think she came across well. If you go into the law and crimes comments, let's go take a look at it right here. This will be interesting here. Let's go in here and check it out. So let's read some comments here. Pull this up while we leave. So we have, I think she really caught herself when she said her husband took her cell phone and didn't have any way to contact anyone. I don't know what that's all about. Okay, female lawyer is killing me with her questions. Horrible prosecutor. Even if she is guilty, the state council is horrendous. They're going to lose their case. It's like she's learning the case as she goes. I'm surprised Lori was much less sympathetic than I thought she would be. It doesn't, to me, seem like a wallflower, and she's too matter of fact. See what the replies were. Rehearsed responses completely. It's been 5 years. She's had to come up to terms with what a toxic situation she was in and how she put herself through it. She's over it. Judge really needs to invest in new sound equipment. So, well, there's some innuendo. It sounds like she should be going for self-defense. Bad judge, rushing to finish. Didn't he rush them yesterday? Yeah, I mean, and that is unfair. Here we have a not guilty. Sounds like Mark drives that truck drunk. Terrible attorneys. Yeah. So you can see there's a mix here among the trial watchers on their opinion on how she's doing. But my concern is the people there that have said, hey, she's not coming across. It was very endearing. But we'll see what happens. It's going to be very interesting. It's going to be a very, very interesting day tomorrow. We will be covering it. I will try to cover the verdict live if I can. But rest assured, we'll be coming on. I'll be covering closing arguments tomorrow and the verdict if it goes down. And like I said, right now, I'm leaning towards not guilty. I'm leaning towards an acquittal. But if this doesn't go that route, the fault lays right at the feet of the defense attorney. Anyways, guys, I hope you've enjoyed this analysis today. Let me know your thoughts. And, as always, in the meantime, until we talk again, let justice prevail. And I'll talk to you soon.